LegalUX mantra number 2 is keep it tight. And this is truly a fundamental principle of advocacy. The more you say, the less they'll retain. The less you say, the more they'll retain. Lawyers often need to be reminded that what's important is not what information is contained in your argument, but rather what information is retained by your user after they've engaged with your argument. Think about it probabilistically. The lower your word count, the higher the probability that your user will engage your argument. Greater engagement yields greater retention, and so brevity increases retention. This is important because the more information a person retains, the more intelligent, reliable, and ultimately authoritative they will appear to the speaker. And note something interesting. It's not important at this point whether the user agrees with your position. What's important is that the user understands and retains your position. It's often helpful to you if your user disagrees with your position. Why? Because understanding and retaining a position that you disagree with is the beginning of a paradigm shift. And a paradigm shift is how you form an opinion or reform an opinion. Now, the point here is not to be brief just for brevity's sake. Professor Garner puts it like this. Imagine a typical law review article. And with all due respect to the esteemed author, you could almost certainly condense the length of a typical article from like 25 pages to 2.5 pages or 15 pages to 1.5. I don't know what the typical length is, but it lose no meaning. The point, though, would not be to publish like little 1-page or 2-page law review articles. The point would be to stack 10 2.5-page powerful, potent sections together into one article. And you'd have a law review article for the ages. By keeping it tight, after framing it right, you acknowledge that your user has a job to do and that you're empowering your user to do their job. You're avoiding argumentitis. Once you've framed it right, any argument that strays even a little bit from the core issue will actually hurt your cause. Why? Because it presents your user with just one more thing to worry about before they do something. So if you're asking your user to dismiss a case with prejudice, for example, or to enter judgment in favor of your client and against your opponent, the very last thing you want is another thing for your user to worry about. Keeping it tight is a struggle of both independence and interdependence. It's a struggle of independence, of course, because you must resist the urge to add unnecessary distraction from your argument. But it's also a struggle of interdependence, because if you somehow have the discipline to keep it tight, your colleagues, in particular supervising colleagues or colleagues with a client relationship, likely will not. Nor will your client. So this is where you should be doing battle. With your colleagues and your clients, not, or at least way more so than with your opponents. Now, note the difference in the verbs between mantras number 1 and 2. Frame it right versus keep it tight. First you create, chisel and create, form. Then you protect. You protect from yourself as much as from others. Lawyers often fret about waiving arguments. And while the basis of this concern is certainly sound, the application of this concern is almost always unsound. The entire point of framing it right is to know which points are necessary to win and which are not. Knowing this is the first step to establishing yourself as a reliable, smart, authoritative figure. Arguing every point, those points that you don't need to win, is probably the quickest way to establish yourself as the opposite, as unreliable, as not smart, as unauthoritative, as somebody that you shouldn't pay attention to. Sun Tzu wrote that when you do battle, even if you're winning, if you continue for a long time, it'll dull your forces and blunt your edge. So it is with advocacy. Keeping it tight means maintaining the integrity of your properly framed issues. It means keeping your edge. The kids today have a saying, say less. I name my company Be Brief. Keep it tight is truly a fundamental principle of advocacy. So, how will you know if you framed it right? Well, regarding the form and style of your argument, I recommend running your writing through BriefCatch. It's a software add-on to Microsoft Word. If you've never heard of it, I suggest you Google it like before you do anything else today. I no longer have an active license to BriefCatch, but I had one for the first 2 versions, and I can tell you unequivocally this. BriefCatch is the best investment that a consciously competent advocate can make. I don't know Ross Guberman, the creator of BriefCatch. I've tweeted at him a couple of times, and my wife can tell you just how excited I was when he responded to them. Regarding the substance of your argument, here's a useful heuristic. If you can have your page or character limit, you've almost certainly kept it tight and framed it right. Now, lawyers always struggle to get in under their page limits or character limits, but the truth is that any filing could and should be done within half your page limits. And don't just take my word for this. Open up a new Word document on whatever project you're working on and get your points down, certainly within half the limit. Just start with bullet points, like just open up the bullet function and just go point by point, just start writing them down in whatever simple language comes to mind. We win because X. Opponent ignores Y case or Y point. This case is distinguishable because Z. And then start developing or fleshing these points out until they become coherent sentences and ideas. And then group those ideas together, 1 point per bullet point. And then as you put them all together into a group, which will become a paragraph, it's 1 bigger picture point per paragraph. And then within those, 1 section, 1 bigger picture point per section. If you're responding to an opening brief or to a response, make a note of every case that your opponent cites. And then note your position on that. It's distinguishable because of X. It's, they misstate the holding, they do this, whatever the points about it, the essence of it is. And what you'll start to do is notice the common denominators that the cases have, that your facts have, that the arguments have. This forms the base of your sentences, your paragraphs, your sections. Now, here's the cool thing. As you flush this out, and this is a new Word document, don't even save this as a document. Just have this as a standalone document for now. As it exceeds the halfway point, start playing around with the variables to see the substantive variables, but also the stylistic variables, to see the cost to get back under half or to stay under half. And what you'll find is that there is a cost to doing this. The cost is unnecessary points, unnecessary authorities, unnecessary facts, unnecessary editorialization, unnecessary legalese, etc. You're going to very quickly develop a deeper understanding and knowledge of necessity, of the essence of your argument. Can you really afford not to have your page limits? I'm going to close with a quote from Judge Leonard Garth. Professor Garner included this quote in tip number 95 of his 4th edition of the Winning Brief. In this tip recommends building in an appellate brief, building the standard of review into your argument. Good idea. Judge Garth, his quote here concerns a discretionary ruling in favor of an unsavory client, a major utility. And Judge Garth talks about how in conference, he and his colleagues, his fellow judges, they all wanted to overrule the district court judge, but none of them could responsibly discount the district court judge's ruling. The judge didn't abuse his discretion, even though the appellate judges might have reached a different result. And so here's the point of the quote here, okay? The utility prevailed, Judge Garth wrote, but it did so because of the tenacity and advocacy of its counsel, who structured his argument on just one issue, the standard of review, and would not let us escape from it. That is how you keep it tight.